What does diversity in the patent field look like? Hi, I'm Elaine Spector, partner and diversity co-chair at Harity and Harity. Out of all USPTO registrants, approximately 20% are white women, 2% are racially diverse women, 4% are racially diverse men, and while there is no data on openly LGBTQ plus patent practitioners or practitioners with disabilities, we estimate the number to be about the same as the general legal profession, at around 3%. Considering gender overlap in these categories, at most, 28% of the patent bar is diverse. And why does this matter? Well, diversity of the patent bar is not only important to those practicing this profession, it is essential for broadening participation in the innovation process by underrepresented groups. Minority inventors want to go to patent attorneys who understand them, who look like them, and who can relate to them. So innovation from these groups will improve when the diversity of the patent bar improves. More innovation will foster a more robust economy, which is good for everyone. So what is being done to improve diversity in this profession? You've probably heard of the Diversity Lab's Mansfield rule, which requires law firms to consider a minimum of 30% diverse candidates for all leadership roles, including women, attorneys of color, LGBTQ+, and lawyers with disabilities. Many organizations have followed suit by implementing metric-based diversity requirements. Clients are now requiring their law firms to give a certain percentage of cases to diverse attorneys and are oftentimes rewarding those law firms with the best diversity metrics. So can this type of metrics-driven recognition be used to improve diversity in a meaningful way based on the current makeup of the patent field? With a portion of diverse practitioners working in-house or in government, we can estimate that at most 20% of diverse practitioners are employed by law firms. Now, if you feed the diverse 20% of patent practitioners into these diversity metric-driven formulas, such as the 30% consideration outlined in the Mansfield rule, satisfying such requirements would entail that 150% of diverse attorneys be interviewed for leadership roles. Similarly, clients that require 30% of cases be handled by diverse practitioners would mean 150% of all diverse practitioners would need to work on them. Stated another way, satisfying the Mansfield rule requires that the number of diverse attorneys be 50% larger than the number currently employed in the patent field. As the facts show, there are simply not enough diverse patent practitioners to meet the 30% requirement numbers, even if every single one of them was interviewed or assigned. This means that firms have to hire away from other firms just to meet these diversity requirements. Large law firms may be tempted to hire diverse candidates away from other firms or in-house legal departments to meet these diversity requirements. This may create a situation where smaller firms or in-house legal departments would lose or be priced out of the market for diverse talent, making it difficult for them to achieve their own diversity goals. This also includes many small minority-owned firms. Ultimately, most firms will be left without a sufficient number of diverse attorneys because there are insufficient numbers in the field. To put it simply, it is statistically impossible for every patent law firm to have diverse candidates make up the 30% of their talent pool that Mansfield and many similar policies require. So you may be asking yourself, what now? How do we fix this? To solve the diversity problem, we must shift from exclusively focusing internally, where each firm and company and legal department focuses on their own particular diversity metrics, to also focusing outwardly. We need to focus on bringing diverse practitioners into the field so that eventually approaches like Mansfield can be successful. Hence the reasons for our Patent Pathways program. So stay tuned to learn more about our Patent Pathways program and how you can get involved with solving the diversity problem in the patent field.